I'm going to show to your lordships a few more facts.
Two more facts are there?
Yes, my lord. Yes. I'm going to show to your lordships a few.
More than what he has told?
Yes, my lord. Yes, my lord. There is something more. And on the same facts that my learned friend has placed before your lordships, my lord, I want your lordships to look at it in a manner in which I would like to place it for your lordships.
Different angle.
Different angle, my lord.
Oh.
Therefore, my lord, that would throw some light, would move assistance to your lordships to see as to whether in this case there is something that requires to be investigated, or the investigation to be scuttled without anything more. Because if the investigation is scuttled and the governor's order is set aside, there will be nothing more to be done in this case. Unless, my lord, it's a question of re-examination, rewriting that's a different matter. But
the submissions are otherwise. If you leave that also, everything subsists. Is what he is.
I will, your lordships may look at that also. I'm not saying no. I'm not saying no, my lord. But there are different ways of looking at the same
That's
issue.
why yours is a different angle.
Exactly, my lord. That's why, my lord, when a lawyer, my lord, wanted an adjournment in court on the ground, my lord, that he had forgotten his spectacles. That said, not necessary. Take my spectacles. I'm not going to grant you an adjournment. And the lawyer, my lord, used the judge's spectacles and still said, I want your on an adjournment. He said, why? I'm looking at a case from your point of view. I want to look at it from my point of view. So, my lord, the way, my lord, one learned counsel looks at it, the way your lordship looks at it, the way I look at it are all different. Therefore, my lord, I want to place it from the point of view of how I would look at it. Now, my lord, I have to give a meaning to explanation one. What is the purpose of saying even if the performance of a public duty by a public servant is not or has not been improper? Now, my lord, suppose, my lord, a legal thing is done in a given case, but it has been induced to be done by a public servant for the purpose of gaining an unfair advantage. Would that amount to an offense under the Act? My lord, explanation one seems to suggest that. Otherwise, my lord, these words shall itself constitute an offense even if the performance of a public duty is not or has not been improper. Therefore, my lord, it appears as if the philosophy of the Prevention of Corruption Act is do not use your public office to obtain an advantage.
Legal or illegal.
Exactly. All right. That seems to be the high pedestal of public morality, which, my lord, the Prevention of Corruption Act seeks to protect, my lord. Then, my lord, please look at explanation 2 in the same section, section 7. For the purposes of this section, the expressions obtains or accepts or attempts to obtain shall cover cases where a person being a public servant obtains or accepts or attempts to obtain any undue advantage for himself or for any other person by abusing his position as a public servant or by using his personal influence over another public servant or by any other corrupt or illegal means. So therefore, my lord, even if you have used your personal influence, not necessarily as the boss, even if you have used your personal influence, it comes within the mischief of section 7. My lord, in a given case, my lord, let's assume a public servant, a minister, my lord, is not in charge of the department. He has no role to play, but uses his personal influence. My lord, would it constitute an offense under section 7? Explanation 3. Explanation 2 seems to suggest, yes, it is. The moment you hold a public office, it carries with it certain obligations and certain do's and don'ts, which are not attached to a non-public office. Therefore, my lord, even if you are not directly connected, but if you have used your personal influence over a particular matter in respect of which a decision has been taken and you are the beneficiary, that itself constitutes an offense under explanation 2 to section 7. Therefore, my lord, the contours of a offense in respect of which an inquiry is required to be held under section 17A are very wide. That's the point I'm trying to make for your lordship's consideration. Lord, it is not like a complaint which requires ingredients of the offense to be mentioned in the complaint, without which your lordships day in and day out interfere under 482 and quash it.
That's after registration of the crime.
My lord, it is after registration of the crime at the stage of investigation. Yes. But it could be, my lord, it has never reached the court, excepting on FIR. Now, in a situation of that kind, even if there is, in the instant case, there are no allegations in the complaint. There's nothing. Still, if the sanctioning authority in the instant case being the Honorable Governor says, well, there is something that requires to be inquired into, not necessarily, my lord, as a list between A versus B, because the philosophy of 17A is different. The whole philosophy of the PCA Act is different. The philosophy, my lord, is to have a purity in public administration. That, my lord, is the paramount object of the Prevention of Corruption Act. If from that point of view, the sanctioning authority says, well, it is as important to be clean as it is to for the people to have confidence in a clean administration. Now, please look at it from that point of view, my lord. It's really not in the nature of a list between the petitioner and anybody else. It is in the interest of purity of public administration. If in that anxiety, if the sanctioning authority says, having regard to the high position that a person is holding, it is necessary that it should be inquired into, I ask myself, what is the scope of interference in a 226 judicial review proceedings? That, my lord, would be the approach I would suggest to your lordships to adopt in this case. It is really not a list between A versus B. There is an element of public interest, and if in that anxiety, the high functionary like the governor, and I will point out to your lordship the judgment, my lord, which of course your lordships will be aware of it, that where a discretion is vested with a high functionary, the courts would be very reluctant to interfere with that order. My lord, your lordships are not going to look at, I would respectfully submit, with the order passed by the governor under 17A, in the same manner in which your lordship will look at an order passed by the Tahsildar.
It was submitted.
My lord?
That was argued. I think.
Yes. So therefore, my lord, if it is so, and I'm going to show you some authorities on that. If that is the position, what is the extent to which this court can go into while examining the action of the governor acting under 17A, being a constitutional functionary? So therefore, my lord, what I would submit to your lordship is, please look at it from the point of view, not as an adversarial litigation. When your lordships are looking at the sanction under 17A, do not look at it as an adversarial litigation. Please look at it from the point of view of ensuring not only there is purity in public administration, but that public confidence in administration is not sullied. If it is damaged, it is restored. What is the best way of restoring, my lord, an eroded public confidence in administration?
Where is it eroded?
Well, let me develop it, but I will show to your lordships that. What is the best? Because it is the very fact that a commission of inquiry has been constituted under the Commissions of Inquiry Act itself indicates that there is an anxiety to get this matter inquired into, because it is a matter of public importance. And that has been referred to by the Honorable Governor in the order. If it was a matter in respect of which no inquiry was required to be done, I ask myself, why was the Commission of Inquiry required? Whole object of the Commission of Inquiry Act is that you will have this inquired into in accordance with the special statute. In order, my lord, your lordship knows, my lord, that the report of the Commission.
So you are satisfied with the Commission of Inquiry?
No. I
What is your suggestion?
I tell you lordships why. Commission of Inquiry Act, unfortunately, my lord, a report of a Commission of Inquiry has no teeth.
We'll give it.
My lord, but the statute doesn't, my lord. The statute doesn't, my lord. In fact, there's a recommendation made by the Supreme Court saying that something must be done, nothing has been done. And the Supreme Court, my lord, has recognized that all these commissions of inquiry report are put in cold storage.
You will not permit.
My lord, but that is an independent and a parallel remedy. That is not necessarily a bar to a sanction under 17A. Therefore, my lord, this submission I made is in answer to the aspect, my lord, of eroding public confidence in public administration. How is it eroded? The very fact that you constitute a commission of inquiry indicates that there is something to be inquired into. Is it something that does not require, is a matter of public importance, is what the Commission of Inquiry Act
Then there
says.
is something being inquired into.
Yes.
So
Yes.
Why all this exercise?
My lord.
Why all this exercise?
Of course, my lord, there are two parallel remedies. Of course, there are two parallel remedies.
Don't emphasize on what is being inquired into.
No, that is only to answer the question, my lord, as to where is the erosion of public confidence. If there was no fear of erosion of public confidence in public administration, then the question of constituting a commission of inquiry would not arise. It is from that point of view I am making the submission that the very fact that the government itself considers that there should be an inquiry into this matter and a matter of public importance itself indicates there is something that required to be inquired into. And all that is required under section 17A is that there is something to be inquired into. And the entire allegations, my lord, are with respect to persons holding public office. Maybe, my lord, ultimately after inquiry, there will be a clean sheet. Maybe not be, I don't know. But why scuttle it at this stage? I mean, why not? Whatever is the truth. Maybe, my lord, there is truth in what is being alleged. Maybe there is truth in what is being said for the other side. We don't know at this point of time. Therefore, at this point of time, would your lordships want the cloud on the purity of public administration to remain? Is a question, my lord, I ask myself and pose it for your lordship's kind consideration. And I would say, my lord, that in matters of this kind, the courts must lean in favor of getting matters inquired. Not
ನೀವು ಅಷ್ಟೊಂದು ಪಾಸ್ ಕೊಟ್ಬಿಟ್ರೆ ಮಧ್ಯದಲ್ಲಿ ಕಷ್ಟ ಆಗುತ್ತೆ.
ಅದು
Courts which side really? Lighter way, yes.
ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ
Lighter ways.
I know.
Mind, yes.
No. I fully
Yes,
understand.
yes.
I fully understand, my lord. We have seen your lordships quite and we have gauged, my lord, to the best of our ability
Yes.
as to what the court means when the court is asking a question. We know that. The one thing that we are never able to gauge, my lord, and rightly so, is what is the final decision.
Oh, if you gauge that, then what is
Exactly, we can't do that. Adu ಸ್ವಲ್ಪ ಕಷ್ಟ.
Yes.
Adu best is not to do it, my lord.
Yeah.
So now, my lord, coming back to the point, my respectful submission to your lordship is please lean in favor of getting matters inquired into. That consideration when your lordships are looking at 19 would be different. And we are not concerned with that
Operates on a
today.
different-
In a different. Now, my lord, having told your lordship that, my lord, I prepared a list of dates and factual aspects, and I want to take your lordship through a few factual aspects, which is relevant.
ರಂಗನಾಥ್ ರೆಡ್ಡಿ ನಿಮ್ದು ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ. ಪೂರ್ತಿ ಇಲ್ಲ. ಎಸ್.